Hello, everyone. Welcome to this special and timely event comparing the incomparable, Kosovo's independence and Russian aggression against Ukraine. I'm Edward P. Joseph of Johns Hopkins SAIS Foreign Policy Institute. And today, we have two distinguished experts from Kosovo who have examined this assertion, longtime assertion, of Vladimir Putin. And these two experts, who I will introduce in a moment, will present their paper, a British-funded paper on this topic, which examines the assertion in detail. I'm going to introduce them now and then provide some context, and then our two speakers will take the floor. Those of you viewing will have an opportunity to ask your questions in the chat. Just use the chat function to ask your questions. And now it's my great pleasure to introduce to you first Dr. Lulzim Peci. And Dr. Peci is the principal founder and executive director of KIPRED. That's the Kosovar Institute for Policy Research and Development. And he's the chair of the board of directors of the Kosovo Open Society Foundation. Dr. Peci is also Ambassador Peci. He served as Kosovo's ambassador in Stockholm, among other posts, going back to serving on the foreign policy team of Ibrahim Rugova back in the 1990s. And he holds a PhD in political science from the Southeast European University and a master's as well from the Institute Ortega y Gasset in Spain. And he earned his degree in electrical engineering at the University of Pristina. So, Luli, welcome to you.
Thank you very much, Ed.
Great. We're going to turn to you in a second, but first let me introduce our other distinguished expert appearing jointly there with Luli in Pristina, and that is Dr. Bekim Sejdiu, who is professor in international law at the University of Pristina and senior research fellow at KIPRED. Dr. Sejdiu is also Ambassador Sejdiu. He served as the Republic of Kosovo's ambassador to Turkey and was also consul general in New York. And he has served as a judge on the Constitutional Court of the Republic of Kosovo, a 6-year term that was completed last year. He has several advanced degrees, including a PhD earned at Nova Universitat in Slovenia. And he and Dr. Peci have both published extensively. So Bekim, we welcome you as well.
Thank you very much.
So now let me just briefly provide some context for this interesting and I would say unusual, even overdue event. As I mentioned at the outset, it's quite timely. This event is quite timely, and we have thanks to that to none other than Alexander Vučić, president of Serbia, who this week on Monday in Slovenia at the Brdo Brioni talks cited the question, Putin's assertion of a link between Kosovo and Ukraine. And here's a quote. This is what President Vučić said. The West, that is the US and EU, want to get out of Putin's hands an argument he has already used in discussions with all Western power wielders. And that is, if you were able to make a precedent with Kosovo, so am I. And that is why they are in a rush. That is why Western powers are in a rush over Kosovo, says Vučić. So that was just this Monday, Alexander Vučić alluding to this very topic that our experts are going to discuss. And this comes, of course, in a wider context of heated, even extreme rhetoric over the summer over this issue of ID cards and license plates, the latter not yet fully resolved, and comes amidst new diplomatic efforts, including the addition of envoys from Germany and France to the EU-led dialogue led by Miroslav Lajčák. Also comes as in Belgrade, they've just finished 2 days of discussion in the Serbian parliament on Kosovo. And as part of that discussion in Parliament, Vučić has restated that the derecognition campaign against Kosovo will continue. So he's made that very clear. More widely, the war in Ukraine is approaching its 7th month, the unprovoked Russian invasion of Ukraine, I should say. And there is still no sign whatsoever of any intention of Serbia to apply and comply with EU sanctions and apply EU sanctions against Russia, nor is there much sign of Western pressure to do so, certainly not of the kind that President Vučić alluded to there in Slovenia. And now let me briefly move from the regional context to the topic of Putin and the use of Kosovo as some sort of justification or rationale. Of course, there is none for the Russian invasion of Ukraine. And to do that, let me have 2 quotes, and I'm going to quickly share my screen with you so you can see that. And then I'm going to hand the floor over to Dr. Peci and Dr. Sejdiu. So let me just share this with you. Stand by, please. And great. I believe you all can see the screen. And let me slide up here. So this goes back to 2014 and the annexation of Crimea. So let's just see these 2 sort of cornerstone comments by Putin. This was done this isn't just offhand. This was done in Putin's speech before the Duma, just before the Duma approved the annexation of Crimea. So in 2014, we have Putin saying, in a situation absolutely the same as the one in Crimea, the West, recognized Kosovo's secession from Serbia as legitimate, arguing that no permission from a country's central authority for unilateral declaration of independence is necessary. It's a kind of baffling, primitive, and blatant cynicism, Putin said. You can't just twist things to fit your interests and call something white one day and black the next one. So that was back in 2014. Then this year, in late April, after meeting with UN Secretary General Guterres, Putin said this: I remember very well the decision by the International Court of Justice back in 2010, which states that when fulfilling its right to self-determination, a territory within a state does not have to seek permission of the country's central government in order to proclaim its sovereignty. Again, making that same argument. This was the ruling on Kosovo, and this is what the ICJ decided, and everyone supported it, Putin said. If so, the Donbas republics, Donetsk and Luhansk, can enjoy the same right without seeking permission from Ukraine's central government and declare their sovereignty, since the precedent has been created. So now I'm going to stop sharing the screen, and we're going to turn the floor over to Luli, you and Bekim, and you will present to us who is twisting the subject and making things black one day and white the next. So with that introduction, Dr. Peci, Luli, you have the floor.
Thank you very much, Ed. Ladies and gentlemen, it's a great privilege and honor for us to present this paper today. But let me thank, first of all, Johns Hopkins University School of Advanced International Studies and my dear friend, Dr. Edward Joseph, for making able this presentation. Let me stress that we are very grateful to you. Also, I would like to express my heartfelt condolences to our British colleagues for passing away of Her late Majesty Queen Elizabeth II. So let me begin with the presentation of this analysis. So the focus of this analysis is deconstruction of the Kremlin's manipulative efforts to draw analogies between NATO's intervention and the independence of Kosovo with the Russian aggression in Ukraine. the focus of this analysis is the construction of Kremlin's manipulative efforts to draw analogies between NATO's intervention and the independence of Kosovo with the Russian aggression in Ukraine. We'll all know that this started in 2014 with the annexation of Ukraine, and it is enforced, how to say, with Russian aggression of February 2022. Our paper is divided in 3 parts. So initially, we did like to present a background of federalism in the Soviet Union and the socialist Yugoslavia in order to show key differences between Kosovo and separatist regions in Ukraine in the past federations. Then we'll introduce Kremlin's manipulative narratives regarding NATO's intervention and Kosovo's independence versus Russian aggression in Ukraine. And most importantly, in the end, we will tackle with key Putin's arguments and his misuse of advisory opinion of International Court of Justice. And we will show clearly the inapplicability of this opinion for the cases of Crimea, Donetsk, and Luhansk.
Stand by. Luli, you know what? While we're waiting, let me ask you and Bekim, anything you want to say about the Serbian reaction to Putin's interview while I'm waiting for your email to come? You know, there was that, I have the link, but there was that, just to mention, there was that momentary, very short-lived anger in Belgrade over Putin's comments there after the meeting with Guterres, but they seem to get over it very quickly. And, you know, the Russian ambassador said, oh, don't worry, nothing has changed in our position on Kosovo.
Well, first I would also join Ambassador Peci, my colleague, expressing how privileged and pleased we are to have this opportunity to speak to such an audience for this very important topic, not only for us actually, but for the entire world. Also, I would like to reiterate our appreciation to the Johns Hopkins University School for Advanced International Studies, and particularly to you, Professor Joseph, for a very well-known and respected name in our region. Yeah, here we are. So the technology does not bring only advantages, as we see today. So there are some disadvantages and problems that may be caused as we are facing this problem with the PowerPoint, and we apologize for that.
No worries, no worries. And Dr. Sejdiu, Bekim, excuse me for jumping in, but am I correct? We have my screen is sharing, so I can control your PowerPoint now, but sorry for the interruption.
Very good.
No, thank you. Before continuing with our paper, with regards to your question, actually, you very rightly pointed out that there was some sort of a bewilderment and confusion in Belgrade after the Putin's remarks. Actually, what if you want our perspective, especially my personal perspective, is we were also confused very much with the answers or the reactions of the UN Secretary General, or at least, I mean, the fact that there was a ruling of the UN court who was being misinterpreted by President Putin, and UN Secretary General did not endeavor to support or actually to defend the decision or the ruling of a court, which is a UN body. But with regards to Serbia, obviously, the Serbian society, in my view, is puzzled. They are still hostage of traditional relations, close relations, and support that they have enjoyed at least during the last 30 years, starting from the 1990s with the breakup of Yugoslavia. They had this unconditional support only from Russia in their policy, especially ambitions towards the newly created republics in the former Yugoslavia. And so as they have enjoyed that support, which was unconditional support and nothing goes for free, so now I don't think they are in a position to have a clear sort of view or opinion when they face this kind of opinions as they did with Vladimir Putin, who obviously with that remark in the meeting with the UN Secretary General in April of this year showed that he actually has this transactionist approach, which is not based on principles, but it's based on calculations and personal calculations, and I mean calculations on the interest of Russia and his personal interest. So it's not that much defending or supporting Serbia, but is making calculation for himself.
Well said, Bekim. Absolutely well said. And again, the irony here, but we shouldn't be surprised about any brazen statement by Vladimir Putin that completely departs from truth or logic. But this one does, as you well stated, transactional, but in this sense, transactional without any logic whatsoever. He's arguing two contradictory things at the same time. So, but you and Luli know far more about this topic than I do. But Luli, would you want to take over, and then Bekim, you'll continue. And I'll just tell me to advance the slide at any moment. And
please advance the slide. Next slide, please. And the other one, and yeah, one more.
Yes. Okay. And please stay close to the mic, Luli, so we can hear you.
Yes. Okay. So Bekim will continue right now.
Well, as Luli explained, we'll provide, because what we did in our paper is we provided a brief constitutional perspective on the position of Kosovo and Ukraine, its breakaway territories in the former communist federations, in former Yugoslavia and former Soviet Union. Obviously, discussing the constitutional designs of the communist federations is a very demanding topic, demanding enterprise in academic sense, and we are not going to go that far. And although we don't think that there is a direct link, at least not an important one, between the constitutional designs of the communist federations with what is happening now in Ukraine. But very briefly, when we speak about the constitutional models in the Eastern communist regions, Eastern communist countries of Europe, it is important to highlight that the conceptual designs actually of the communist federations were articulated first by Lenin and experimented for the first time in the Soviet Union. And Lenin's federal model or federalist model was centered on the balance between the unity of one people, which means the Soviet working people, and the diversity of many ethnic nations like Russians, Ukrainians, Georgians, Armenians, and so on. So, and the communist ideology was what kept together the unity or the link between the unity of one people, the diversity of many nations, which constituted that one people. And this design, as I said, was articulated for the first time by Lenin and practiced by the Soviet Union, and also was taken over by former Yugoslavia as a general constitutional model. Of course, there were details because the communist and Soviet federations were not exactly the same. I mean, the Soviet system was more complex, more centralized, and it embodied more layers of governance. So according to the last constitution of the Soviet Union, the hierarchical order of different territorial layers of political power was as follows. So first you had the Union republics, the 15 Union republics, then you have autonomous republics, then you had autonomous regions, and then you had the autonomous areas. Only the 15 Soviet republics were recognized as socialist states. And hence they, according to the Soviet constitutions, they had a constitutional right to secede. So this right, according to the Soviet constitution, belonged explicitly only to the 15 republics. The autonomous republics had a high level of autonomy, including legislative power, but they were not constitutive parts of the Soviet Union.
Now, with regards to the socialist Yugoslavia, the Yugoslav Federation was, as I said, the model was constructed along the Soviet communist constitutional concept. But according to the constitution, to the last constitution of Yugoslavia of '74, Yugoslav Federation consisted of 8 federal units, 6 republics and 2 autonomous provinces, Kosovo and Vojvodina. So the position of the autonomous provinces was a dual, so they had some sort of a dual constitutional status. So they were constitutive element of the Yugoslav Federation, but at the same time, so they had a constitutional status at the federal level, but also a nominal link with the Republic of Serbia, although they were not under, as we have elaborated at length in our paper, actually, they were not subordinated to the Serbian state institutions. Rather, they had the decision-making power at the federal level. This status was not enjoyed by either by Crimea nor by Donbass, the so-called Donbass republics, Donetsk and Luhansk. So they had no federal status whatsoever during the Soviet Republic, during the Soviet period, whereas Kosovo, as I said, had a dual status, but basically according to the constitution of 1974 of Yugoslavia, Kosovo was a federal unit, so in a way it was a constitutive element of a country which does not exist anymore, of Yugoslav Federation. And moreover, similarly with other units of the Yugoslav Federation, it had the right to veto every important decision making at the central level, federal level, including, for example, the changing of the borders. So the borders of Yugoslavia could not be changed without the consent of the 8 federal units, including Kosovo. The borders of the federal units also could not be changed without the consent of the federal units, including Kosovo. I'm mentioning just 2 examples to show that as opposed to the Crimea or other regions within Ukraine and other Soviet republics, Kosovo had the federal status with the decision-making capacity clearly stated in the constitution at the federal level, and this was not the case with the Crimea, Donbass, Donetsk and Luhansk. Basically, they were autonomous regions. They were even not republics, autonomous republics in the Soviet times. And as we all know, Crimea was part of the Russian Federation within the Soviet Union until '54, when Khrushchev decided to give it to the Ukraine. Then it became an autonomous region of Ukraine. And only in 1991, its status was upgraded to that of the republic within Ukraine, but still under the Ukrainian constitutional order and without right to secede. I'm speaking in the constitutional legal perspective. We will discuss legal issues again when we discuss the International Court of Justice and its opinion on the proclamation of independence of Kosovo and the attempts by Russia, as you pointed out, the attempts of Putin to manipulate, basically to misinterpret that opinion. But before going to that, I will pass the floor to Luli, who will speak about the international political and legal context of the NATO's intervention and the in comparison with what the Putin is trying to do. I mean, to create such a narrative with regards to Crimea and other parts of Ukraine as well. So, Luli.
Right. Luli, just 1 second before I'm going to switch slides, but Bekim, just that was so clear and quite important. That what you've done here is set out how fundamentally different the core constitutional status was, so that there is no parallel. There's no, you start from the beginning, there is no basis for some parallel between Kosovo with respect to its position in former Yugoslavia and these breakaway, so-called breakaway Crimea, Donetsk, Luhansk in Ukraine. And that was very clear. I just wanted to point out one very important point, is that Kosovo's position in former Yugoslavia, am I correct here, Bekim, was unilaterally changed by Belgrade in 1989, correct?
You are correct, and that is the origins of the process of the breakup of former Yugoslavia, of non-consensual breakup of former Yugoslavia, because that was changed unilaterally by Milosevic through using power, force, brutal force. Kosovo was put basically under some sort of a martial law, and what followed was that Albanians, of course, were kicked out of basically excluded totally from the public life in Kosovo. So some sort of an apartheid of regime was installed, but that is a different story. But in the constitutional perspective, as you said, the first step that Milosevic took to destroy the federal Yugoslavia was changing unilaterally the federal status of Kosovo and Vojvodina, and that was opposed not only by Kosovo, but also by most of the other republics in the former Yugoslavia.
Great. Thank you for that, Bekim. Excellent. Luli, you have the floor.
Yeah, next. Thank you very much, Ed. So what I'm going to present here is manipulation that Russia is making by comparing the NATO's intervention in Kosovo with its aggression in Russia. So I'm going to introduce very briefly the background of NATO's intervention in Kosovo, the process of it. So first of all, we shall have in mind that NATO intervention in Kosovo was preceded by 3 United Nations Security Council resolutions under the provisions of the Chapter 7. And the intervention actually started after Serbia's rejection of the contact group drafted Rambouillet Accords, in which participated Russia as well. Secondly, the NATO-led peace enforcement mission, KFOR, has entered Kosovo only after the agreement with the authorities of Yugoslavia and Serbia at that time, and with the explicit authorization given by the United Nations Security Council Resolution 1244. This means that NATO has not occupied any part of territory of Yugoslavia because it entered Kosovo with the consent of Yugoslavia, and which was also authorized by the United Nations Security Council. Plus, we have to recall the fact that Russia participated in the KFOR mission from 1999 to 2003. Even in 2001, President Putin paid a visit to Russian KFOR mission in Kosovo. On the other hand, Russian annexation of Crimea in 2014, an invasion of Ukraine in February 2022 are actually pure acts of aggression against the territorial integrity of Ukraine. Why? Because the entrance of Russian troops and military was neither has been done with consent of Ukraine, nor it was authorized by United Nations Security Council. And this is the key difference between NATO's mission in Kosovo and Russia's aggression in Ukraine. Next slide, please. Then, when it comes to international reactions regarding the NATO's intervention in Kosovo compared with Russian aggression in Ukraine, the situation is completely different. We have to recall the fact that in March 1999, United Nations Security Council rejected the draft resolution, which has been drafted by Russia and India and Belarus, if I'm not wrong, for the cessation of the use of force, of NATO force against Yugoslavia. But on the other hand, NATO's airstrikes against Yugoslavia were never condemned by any UN body or any other international organization. And what is happening with Russia's aggression in Ukraine? So the Russian aggression and illegal annexation of the territories of Ukraine were condemned by several United Nations General Assembly resolutions. Perhaps more than 10. I'm not able to count them by heart right now, but they are clearly presented. All of them are presented in our paper. On the other side, also, United Nations General Assembly suspended the rights of membership of Russia in the Human Rights Council. And what is the most important thing, which is a decision that has a binding effect, it's the fact that ICJ indicated provisional measures demanding suspension of all the military operations of Russia in the territory of Ukraine, which were disregarded by Kremlin, and they are not respected. We know that UN General Assembly resolutions are considered as a soft law, but the decision of International Court of Justice on this case belongs to the provisions of the hard law, to the provisions of international law. Next slide, please. Then I'm going to introduce the process, the political process of Kosovo's independence in comparison to separatist regions of Crimea, Donetsk, and Luhansk. First of all, Kosovo was the last remaining problem of the bloody dissolution of Yugoslavia. And this fact has been acknowledged by Russia as well. We have to recall the contact group statement of fall 2006, which stated exactly what I'm presenting here. And Russia was part of the contact group. Then the independence of Kosovo was a result of the UN-led negotiations, which were led by the UN Secretary General Envoy President Ahtisaari. Kosovo declared independence based on Ahtisaari's plan, which was, on the other side, rejected by Serbia. And after many efforts by United States, Great Britain, and France to push Russia to accept this plan. But it is one important element, a legal and political point here, actually, that the resolution FEL 44 did not make it mandatory for the final status of Kosovo to be approved by the United Nations Security Council. When, on the other hand, separatism in Ukraine did not derive from the dissolution of the Soviet Union, but it was orchestrated by Russia and their doctrine of the Russian world, which is briefly also expressed, analyzed in our paper. Then the annexation of Crimea and recognition of the independence of Donetsk and Luhansk regions by Russia were not a result of any international process led by United Nations or any other organization. One might say that, okay, that the Minsk agreements and Normandy format is similar to that with Kosovo, but it's not. Why? Because the Minsk agreements didn't have the nature of peace accords. For the status of these separatist regions, but they were basically ceasefire and conflict de-escalation agreements. And here is the fundamental difference between independence of Kosovo and the separatist regions of Crimea, Donetsk, and Luhansk. Next slide, please, Ed. Then, when it comes to international reactions, Kosovo's independence was neither condemned nor called to not to recognize it either by United Nations or any other international organization. This is not the case with separatist regions of Ukraine, because UNGA has condemned with several resolutions the annexation of Crimea and have asked all UN member states not to recognize its altered status. And the same happened also with regarding the recognition of the independence of Donetsk and Luhansk by Russia. And this is the fundamental, and when it comes to international reactions, this is also the fundamental difference between the independence of Kosovo and the separatist regions of Ukraine. And the difference is very clear, I think. Please, next slide. Can you move to next slide, Ed, please? Right now, I will pass the floor to my colleague, Bekim.
Yes, you should have the ICJ on your screen.
Yeah.
Yes, yeah.
Yeah.
Well, going back to the episode of the discussion between Vladimir Putin and Secretary General of the UN in April this year, which resembled pretty much for those who have
Wait,
background.
Bekim,
Yeah.
1 second, one second, please. And let me, before
Yes.
you go on, let me just quickly, because now you're going to take our audience into a different, equally important topic, this question of the decision by the ICJ. Let me just quickly summarize so people understand these very cogent points that Dr. Peci has just put forward. So I just want to just quickly list them and summarize them so people just get the thrust of the importance of what Luli has just stated. The number one, no comparison whatsoever with Russian invasion of Ukraine, because KFOR is not an occupier. It entered Kosovo by consent. That NATO's actions prior to that, the air campaign, was not condemned, whereas obviously the Russian invasion has been routinely condemned, including by the General Assembly. That you have an ICJ call for Russia to suspend all operations. There was no such call whatsoever with respect to NATO intervention. That the independence that emerged in 2008 was the result of a UN-led process there, and that the foundational UN Security Council resolution 1244 did not, as Luli told us, did not make UN Security Council approval of independence mandatory. And Luli distinguished that UN-led process that arrived at the 2008 independence of Kosovo with the Minsk and Normandy processes, which are not, as Luli emphasized, even though these are international, OSCE, Minsk, these are not peace accords. These are de-escalation and ceasefire. I just wanted to summarize those points before you go ahead on about the 2010 advisory opinion of the ICJ. Dr. Sejdiu, please, you have the floor.
Yeah, thank you, Ed. Well, I was, as I was saying, as a former judge, for judges, it's not easy to speak the politicians speaking about their decisions, because at best they do not understand them, and at worst they misinterpret them. With regards to the ICJ's opinion on the proclamation of independence of Kosovo and the way that it has been interpreted by Putin, I would say the second case is here like applicable. Why, before going to explain the decision itself or the advisory opinion, because the International Court of Justice, as we all know, is one of the principal organs of the UN, and it makes decisions and it issues advisory opinions. This was one of the most landmark advisory opinions in my view, and it's not only my view, but of, I mean, this view is shared by many experts of the International Court of Justice, and not only because it dealt with an important issue, such as the case of Kosovo, especially at that time, but also it touched upon some of the major principles and aspects of international law, namely creation of the new states, declaration of independence, recognition, and so on. As a small background, historical background, as we all know, when Kosovo declared independence in 2008, in September, Serbia succeeded to sponsor a resolution in the General Assembly which referred the issue of the Kosovo's independence to the International Court of Justice. And this was actually, ironically, this was held as a big victory in Belgrade when Serbia succeeded to pass the resolution in the General Assembly to refer the issue to the International Court of Justice. Around 2 years later, in July 2010, the International Court of Justice issued the advisory opinion on the proclamation of independence of Kosovo. It is important here, at least from the legal standpoint, to underline that as we can see and as the audience can notice in the screen, the question that was addressed to the International Court of Justice by the General Assembly for an advisory opinion was as follows: is the unilateral declaration of independence from the provisional institutions of self-government in Kosovo in accordance with international law? And this question was drafted by Serbia. And it was presented as such to the General Assembly, and then General Assembly decided to refer the case to the International Court of Justice. If you could please go to the next slide. In order to answer the question, the International Court of Justice made its reasoning on 3 legal grounds. So the question was the declaration of independence in contradiction with international law? This is what Serbia asked the court, the World Court, through the United Nations General Assembly. And the ICJ based its reasoning on 3 legal grounds. First, they looked into the general international law, or what is called in the legal doctrine as lex generalis. Second, they went to the they analyzed the United Nations Security Council Resolution 1244, which, as we know, and as it was explained by my colleague, Ambassador Peci, was the resolution which was adopted in June 1999, and which placed Kosovo under the United Nations and NATO-led, under the United Nations administration. So first, the International Court of Justice analyzed the general international law on the declarations of independence. Then they went on to analyze what we call lex specialis, which means the special legal acts which apply to the concrete situation. And in this case, in the opinion of the court, that was the UN Security Council Resolution 1244 adopted on Kosovo, and the constitutional framework of Kosovo, which was promulgated by the UN mission in Kosovo as a regulation. Now, for those who have no background in law, this is a bit complicated, but I will have just to explain briefly that from 1999 until 2008, when Kosovo declared its independence, Kosovo was put under the international administration, which had 2 components. The first component was a civil one, and it was like the UN-led civil administration over Kosovo. And the second component of the international administration of Kosovo was a military, and it was a peace enforcement mission under the UN's Security Council Resolution 1244, but also led by NATO and with the participation of other countries. So to go back to the legal arguments, the International Court of Justice looked at these 3 legal bases to come up with the conclusion that the independence of Kosovo, the proclamation of the independence of Kosovo, did not violate any applicable rule of international law. If you can please go a slide further to just see the reasoning of the court. What you can see in this slide is based on the opinion and the reasoning of the International Court of Justice, why the declaration of independence of Kosovo did not violate international law, and hence it was in compliance with international law, and why this reasoning does not apply to the cases of Crimea, Donbass, or Luhansk. As I said, in order, as the courts do, in order to come up with a ruling, you have to analyze the legal grounds which pertain to the specific situation. In this case, the court first went to the general international law, and the court found or concluded that general international law does not contain prohibitions on declarations of independence as such. So there is no a priori prohibition, or there is no any norm of international law which prescribes when, how the declarations of independence of nations can be promulgated. The only exemption, according to the court, exists if the declarations of independence involve egregious violations of the norms of general international law, in particularly the peremptory norms, or the norms that are called in Latin jus cogens. So, according to the court, the general international law does not prohibit the issuances of the declarations of independence unless those declarations of independence violate any of the fundamental principles and norms of international law. And in order to give examples, the court referred to the cases of Southern Rhodesia, Northern Cyprus, and Republika Srpska, Bosnia and Herzegovina, and explained that in all these cases, there were UN resolutions which basically called other countries not to recognize if these entities would declare independence, because that would be in violation of the fundamental norms of international law. In Kosovo, the International Court of Justice found that no such principle, general principle or norm of international law was violated when Kosovo declared independence. So this is the first ground in which court based its opinion. With regards to the Crimea, Donetsk and Luhansk, it is very obvious that Russia's intervention in Ukraine and the separatism in these regions is in grave violation of the fundamental principles of the general international law. So UN did not make such finding with regards to Kosovo. I mean the UN court, the International Court of Justice, but the General Assembly, as Ambassador Peci explained, made such findings with several resolutions when it comes to Ukraine, to Crimea, Donetsk, and Donbass, and including the International Court of Justice itself has issued what we call a provisional measure imposing on Russia the legal obligation to withdraw its forces from Ukraine and to stop the military operations. Of course, that was not obeyed. But to conclude on this point, so the court found that the general international law contains no prohibitions of the declarations of independence unless they violate any of the fundamental norms of the international law, and this was not the case in Kosovo. And by this logic, this is the case in Ukraine, because the separatism of Crimea, Donetsk, and Donbass is a direct product of a violation of one of the core principles of international law, that is the principle of non-use of force and respect for territorial integrity of states. Can you please go to the next slide?
Yes, I will, Dr. Sejdiu. Let me just quickly mention to our audience to please actually send your questions in on the Q&A using the Q&A function, and we have our able assistants here eagerly awaiting and will convey to me the questions. So in the Q&A function. If you'll allow me, Dr. Sejdiu, just to emphasize one critical point while it's on the screen, is that the ICJ specifically distinguished Northern Cyprus, and as well as Republika Srpska, which had been mentioned in at times in the context, and maybe later we'll come to Greece's position on this, and the fact that it appears Athens has understood and accepted that Kosovo and the Northern Cyprus case are in fact quite different and distinct, and that Northern Cyprus does not present that situation does not present an obstacle for Greek recognition of Kosovo. But here's the next slide.
So after the court, after analyzing the general international law vis-a-vis the declarations of independence and finding out that as a general rule, international law a general international law does not prohibit a priori the declarations of independence, and this happens only when those declarations are product of a grave violation of fundamental principles of international law. That was not the case in Kosovo. Then the court went a step further to analyze what we call in legal discourse lex specialis, so the special legal acts which apply to Kosovo for this kind of situations. I mean, meaning the declarations of independence. And here the court delineated the lex specialis by looking into two interrelated legal acts. First, the UN Security Council Resolution 1244, which we have explained, adopted in June 1999. And second, the constitutional framework of Kosovo, which was adopted in 2001 and was promulgated as a UN regulation. So this is quite complicated, as I said, perhaps not easy to understand, but during the UN's administration over Kosovo, all Kosovo laws were promulgated as UN MIC, so United Nations Missions regulations. So because UN had legislative power in Kosovo during that period. So this constitutional framework was adopted basically as a as the regulation of the UN mission, but regulated specific domestic issues in Kosovo. It was, as the name indicates, it was some sort of the constitution of Kosovo during the international administration. So the International Court of Justice then went on to analyze the UN Security Council resolution and the constitutional framework. And then it concluded that none of these legal acts was violated when Kosovo declared its independence, because both of these acts, especially the Security Council Resolution 1244, speak about the process for determining the final status of Kosovo, but do not prescribe the epilogue of such a process. In other words, this resolution and also the constitutional framework of Kosovo did not tell what should be the final status of Kosovo, nor did they made it mandatory for that final status to be approved by the UN, as Ambassador Peci said. So rather, these two legal acts prescribed only the process for reaching out the final status of Kosovo, by leaving open what this final status per se should or might be. On the other hand, applying this logic of the International Court of Justice to the cases of Crimea, Donetsk, and Luhansk, in my view, and we have explored this in our paper, actually, there are three legal acts which might be interpreted as forming the lex specialis in the case of Ukraine, and all of them were violated by Russia. The first was the Budapest Memorandum of 1994. The second was the Treaty on Friendship, Cooperation, and Partnership between Ukraine and Russia in 1997, and the third were the Minsk agreements, which Ambassador Peci elaborated. All of these three acts, agreements, so in legal sense, they constitute agreements between two independent countries, were violated by Russia, because all of them, especially the Budapest Memorandum and the Treaty on Friendship, Cooperation, and Partnership, oblige the signatory powers, which means Russia, to respect the territorial integrity of Ukraine. So Russia signed these treaties, and now, as we see, Russia is bluntly violating these treaties. So just to put it in the comparative perspective, as we see, as I said, and as we see from the slides, first, the general international law contained, as the court said, no prohibitions with regards to the independence of Kosovo. There were no obstacles for Kosovo to issue the declaration of independence and to become an independent state. But this is not the case with, I mean, this standard does not apply to Ukraine. The lex specialis in the case of Kosovo, it means the resolution of the UN Security Council 1244 and the constitutional framework of Kosovo contain no prohibitions for Kosovo to declare its independence, whereas on the other hand, Russia has violated three specific the agreements that it had signed with Ukraine, and all of them contained a direct and explicit obligation not to violate the territorial integrity of the signatory states, which means Ukraine as well. And then the Constitution of Ukraine, if you could please go to the next slide. As opposed to the constitutional framework of Kosovo, which I said did not contain, as the court reasoned, the International Court of Justice did not contain any prohibition with regards to the declaration of independence of Kosovo. The Ukrainian constitution is quite specific. If you could please go to the next slide, I've added some quotes, some articles from the Ukrainian constitution, which clearly and explicitly sets legal prohibitions for the declarations of the independence or changing of the territorial and the political status of Crimea and any other part of Ukraine. So let me emphasize here that in Ukraine, the Ukrainian constitution continues to be the highest legal norm in the country, and that governs also the territories of Crimea, Donetsk and Luhansk. Article 1 of this constitution, the Crimea has its own constitution as well, but the constitution of Crimea also says in Article 1 that Crimea is an integral part of Ukraine and shall have only the powers which are conferred upon it by the constitution of Ukraine. So Crimea does not have the right, according to its own constitution, which was in force and which is legally still in force, to assume powers which are not prescribed to it by the constitution of Ukraine. Moreover, Article 73 of the Ukrainian constitution explicitly sets or prescribes that the territory of Ukraine is, the change of the territory of Ukraine is resolved exclusively by an all Ukrainian referendum, which means that a Ukrainian constitution, which as I said, is the highest legal norm in the country, the highest legal act in Ukraine, clearly stipulates that in order to have any altering of the territory of Ukraine, there needs to be an exclusive all Ukrainian referendum. Moreover, the constitution of Ukraine in some other articles sets a clear prohibitions to amend the constitution itself, which would put in danger the territorial integrity of the country. As I said, this was not the case in Kosovo, whereas the constitutional framework of Kosovo that was adopted by the UN itself prescribed the process for determining the final status of Kosovo, because Kosovo, during the United Nations administration period, Kosovo was put under some sort of the UN legal order, interim legal order. That was the basis for the court, beyond the general international law, to determine or to come up to the conclusion that the Declaration of Independence of Kosovo did not violate any norm of any of the UN acts that applied to Kosovo at that time. Beyond this, if we could please go to the next slide.
I will in 1 second, Dr. Sejdiu, and just again, remind our viewers, please send in your questions through using the Q&A function. And Dr. Sejdiu, let me just point out one thing here, in case someone is watching and they're saying, and they look at this split screen and they say, you're comparing the Kosovo constitutional framework with the Ukraine constitutional framework. What about the Serbian constitutional framework? That you should be comparing that. And I just want to suggest, and you tell me if this is correct, Dr. Sejdiu, that the reason for that is that question, the assertion of the Serbian Constitutional Court, was done by the approach to the International Court of Justice. So that was precisely the question. It isn't that the Serbian constitutional claims are ignored here. It's that you've discussed them already in the context of Serbia's claims that it's question that it drafted through the UN General Assembly to the court. So we're not obscuring the Serbian constitutional claims. It's that you've discussed and addressed them already with that thing. Would that be correct? And
yes, if I just can add a little bit more in order to make it a bit more simple, perhaps for the audience, especially for those who have no legal background. In 1999, the NATO's intervention to stop the unfolding genocide in Kosovo was stopped by the was concluded with the adoption of the Security Council Resolution 1244, which was voted also by Russia. Now that resolution placed Kosovo under the United Nations administration. So the sovereign power in Kosovo, in a way, became the UN. And the legal order that applied to Kosovo was a legal order that was created under the United Nations Security Council Resolution 1244. Based on that resolution, The UN deployed in Kosovo, the UN had the legislative capacity, and the UN enacted a regulation which was called the constitutional framework. So the constitution of that period was in a way enacted by the UN. And obviously, as it derived from the Security Council resolution 1244, it was the superior law in Kosovo. So the laws of Serbia did not apply in Kosovo, especially, I mean, obviously, I've been speaking in general, constitution and the important laws. I mean, because there were some issues of not of political relevance, whereby the laws have continuity. But as a general, to understand it, during that time in Kosovo, constitution was the UN regulation 1244, which was called the constitutional framework of Kosovo. So the legal order that existed in Kosovo at that time was an interim order, and that was created by the UN under the UN's umbrella based on the Security Council resolution 1244, which was voted in the Security Council based on Chapter 7, and which was voted by Russia as well.
Excellent.
So I don't know, did I make it more clear or not? But it's
you did
in legal sense.
You did. No, and that's very important legally and fundamentally. And thank you for that, Dr. Sejdiu. Your point is that actually the legal character of Kosovo, including with respect to Serbia, changed by virtue of Security Council Resolution 1244, which was voted on by Russia. So that actually changed and altered the legal standing and character of Kosovo, that itself. I was just taking even a wider, broader point that any complaint in Serbia about your interpretation or such an interpretation has been addressed in the sense that Serbia didn't accept and it rejected the Declaration of Independence, and it took its challenge to the International Court of Justice, and you explained very thoroughly the court's reasoning and the basis for it. But I was just saying, so that no one thinks, well, gee, you're obscuring Serbia's constitutional claims. In fact, you dealt with them and explained them. It was asked and answered. There's a separate question maybe I could ask you now. Do you want to say anything about the continuing claim in Serbia and some others that, that ICJ decision only spoke about the Declaration of Independence and didn't address statehood? Do you want to say anything about that, or we can entertain that?
No, I would definitely like to add a comment on that, but if you could please just go to the next slide, because it is related to the specifically to this question. Perfect. So one of the arguments of Serbia basically in the court was that the territorial integrity of Serbia was violated by the Kosovo's Declaration of Independence, and the court held that the principle of the respect for territorial integrity of states applies in relations between sovereign states, not within them. So this principle applies to relation state to state, not what happens within the state. And this means that it does not apply to the non-state actors or entities emerging or exercising their rights, in this case, the right to self-determination, although the court did not go that far, basically. But the court, in a way, said that first, the principle of territorial integrity of states applies in relations between states, and Kosovo's independence derived from not from the 1999 intervention, but from the legal order, from the interim legal order that was established in Kosovo with the resolution 1244, whereby Kosovo was placed under the international nations administration. And that resolution, as I said, spelled out the process for determining the Kosovo's final status, but it neither said what the status should be, nor asked explicitly for that status to be accepted by the Security Council or any other UN body. So, with regards to the Ukraine, the principle of territorial integrity and the prohibition of the use of force applies because, I mean, again, taking as a point of reference the interpretation of the International Court of Justice in the case of Kosovo, because the self-proclaimed independences of Crimea, Donetsk and Luhansk
or a direct product of Russia's aggression against Ukraine. So they are not processes that have evolved from within and spontaneously, but they were a direct outcome of the Russia's aggression, which means that the principle of territorial integrity applies in this case because Russia has used force against Ukraine. And as a result of the use of force of Russia against the territorial integrity of Ukraine, we have this self-proclaimed independent phantom entities of Crimea, Donetsk, and Luhansk. Again, going back to the interpretation of the International Court of Justice and using and relying on the reasoning of the court. As I said, just to summarize this legal argument, first, the question that was presented to the court was formulated by Serbia itself. Now, hypothetically, if Serbia would have framed different question, in my view, the opinion of the court can be even more clear on the right of Kosovo to become independent state, but that is a hypothetical, again, based on my personal views, but still, Serbia itself asked the court for the opinion. Serbia framed the question. Serbia refuses to recognize the court's opinion. Serbia is misinterpreting the opinion of the court, for which it has, it itself has asked for. The court made it clear that the declaration of independence of Kosovo did not violate any general norm or principle of international law, nor specific legal acts that apply to Kosovo, which are the United Nations Security Council resolution and the constitutional framework of Kosovo. As I said, in the case of Ukraine, if we use the legal reasoning of the court, it is very obvious that all these three legal grounds would lead to the conclusion that the actions of Russia and its direct outcome, which is the self-proclaimed independences of Crimea, Donetsk, and Luhansk, are in clear violation of the general international law because they are product of a aggression of one country against another. They are a direct product of that. Moreover, these acts, these actions violated three international agreements at least that Russia has signed. The Budapest Memorandum, the Friendship Treaty, and the Minsk agreements. And obviously they are, the actions of Crimea, Donetsk, and Luhansk are in stark contradiction to the constitution of Ukraine, which is the highest legal act in the country. So with this, we conclude the legal argument with regards to the International Court of Justice. And we have the last slide, if we could go just as a summary. Obviously, as a conclusion, there can't be any analogy between the cases of Kosovo and the separatist regions in Ukraine. The cases are totally different. We have analyzed the historical context whereby we focus more on the constitutional status of Kosovo, Ukraine, and its separatist regions in the respective federal communist federations. They are different in legal aspects because, as we explained, the International Court of Justice's the legal reasoning is very clear, and is very clear based on that reasoning that Russia has violated international law by its actions in Ukraine, and also in the political aspect, as it was elaborated by Lulzim, the independence of Kosovo, the NATO's intervention, and so on, was a result of an international process with the UN having an important role, if not the leading one. This is not the case. This is not obviously the case in Ukraine, whereby the international community, including the UN itself, has clearly condemned the actions of Russia and its consequences, or at least its attempts to grab parts of the Ukrainian territory. So we would stop here with our presentation. We apologize again for having these technical problems, and we would welcome obviously any question or comment by the audience.
Great. Thank you. I'm going to convey some of the questions. I'll distill them in my own words for you both. First, let me say, and I think this is echoed by the viewers, that you have made a very clear, cogent, and convincing case that there's simply no basis to the argument of any kind of a parallel or some sort of quote precedent as asserted by President Putin between the Kosovo case and the Ukraine case. Let's take it to from the political and legal contrast. Let's take it to the reality. Let's come to the reality. And let me ask you both, Dr. Peci, Dr. Sejdiu, this question. Number one, why does Putin continue to make this argument? What, besides just sort of some flimsy so-called rationale, does he have an angle? Is he angling for something here? That would be my and if so, what do you make of President Vucic's remark that he says this week? He says, I'm under all of this Western pressure because they want to take this argument away. Do you think it's just a completely contrived remark? And if not, what are the implications if not? So, but the first question is, why does Putin bother doing this? Because he has no other rationale, or does he actually have some concrete aim in mind here?
Well, if I may respond, thank you very much for your question. Well, first of all, I think that Putin is using this
Stay close to the mic.
Actually, how much accurate is Putin in using this argument is very clear from the sense of Russia not to recognize Kosovo. Because if Russia would really respect the International Court of Justice, it should have had recognized Kosovo until now. So this tells a lot about the hypocrisy of Russia. Secondly, Russia is using this argument by interpreting only the general norms of international law, which do not forbid declarations of independence in any sense, but he is undermining the lex specialis in the case of Ukraine. Correct me, my friend is a lawyer, and here is the difference. So he's taking from the judgment of International Court of Justice what he wants, but he doesn't he's not taking from this opinion its entire how to say content and the implications of the entire content of the International Court of Justice. In political terms, Russia wants to use it for introducing the anarchy in its near neighborhood and for threatening not only Ukraine, but all other countries which do not subordinate to its to its how to say will, that he can use the very same argument for invading other countries. Actually, he has done it in the past with Georgia, but we do have an earlier cases with Moldova and the region of Transnistria. So in general, I think that Kosovo's argument from the beginning has been used by Russia for its purposes in the area which is called near abroad, and because Russia has not a specific interest in the Balkans, a part of and in Kosovo, a part of weakening EU and NATO in the region.
And please, Dr. Sejdiu, go ahead.
If I may just add, well, the legal and political aspect of it. In legal sense, perhaps it's become
Stay close to the mic on the laptop.
Well, if I may just, add a little bit to it as a follow-up to what Lulzim said. There is a legal and political dimension of this. In legal sense, perhaps it sounds too dogmatic, but the international community has established a body to make interpretation of international law, and that is the International Court of Justice. So the countries which want to respect international law have to respect the rulings of this court, because that court has a mandate to make the legal interpretation in any controversy about the international law. Obviously, as Lulzim said, the problems in the former Soviet space are much older. The Russia's actions in its near abroad space, which resulted in creation of some sort of a phantom territorial entities, are much older than Kosovo became independent. In my view, and this is the political aspect of this, in my view, in order to understand this actions of Putin, we have to go a little bit further back in history, or in the recent history, and to understand how the conclusion of the Cold War was interpreted or was felt in Russia and in the West. And I think this is the origins of this policy, as opposed to the Western countries, which interpreted the Cold War in ideological terms, as ideological contest with the Soviet communism. In the political and I would say intellectual circles in Russia, this was perceived as a national rivalry between Russia and the West. And so the conclusion of the Cold War, the disintegration of the Soviet Union and Warsaw Pact and so on, was not interpreted or construed through the ideological lenses, but it was perceived and experienced and felt as a national disaster for many Russians, including Vladimir Putin. And this by default makes him a revisionist leader, and Russia a revisionist power. So a power which is not happy with the rearrangement of the geopolitical space in the Eastern Europe with the ending of the Cold War. So the near abroad concept is a direct product of this, in my view, and this is, if we are to simplify, this is expressed by the let's say attempts of Putin to give to Russia, or to attribute to Russia the right to decide how much sovereign can the former Soviet republics be. Of course, with the exception of Baltic states, that's a different story for obvious reasons. But Russia attributes to itself the right to decide how and in what way the former Soviet republics can be independent. And obviously then there is an ideological dimension to this, because Russia allows more, I would say, perhaps sovereignty to the countries which are in the former Soviet Union, which are at the same time the Putin satellites, and also ideologically do not represent a threatening or a problematic model for Putin. But as I said, in my view, politically, the origins of this developments that they are witnessing in Ukraine are directly linked to the ending of the Cold War in the way that was interpreted, the narrative of Russia about the rearrangements which resulted from that period.
Great, and let me ask you, both of you, Dr. Sejdiu and Dr. Peci, then let's take this question, and that's quite interesting, that this point that fundamentally Putin is a revisionist who has distorted or had his own interpretation of shared by other Russians. Let's take this to the who is attempted to revive Greater Serbia with now Serb world, similar to Russia world. Luli or Bekim, how do you see in this context, this framework that Bekim has just provided, that as a revisionist, how do you see Serbia's posture here? Serbia claims that it's fighting against revisionism, that its own territorial integrity, that it is obviously ignoring all of the its own case that it engineered to the ICJ. So how do you examine this in the context of Belgrade today and Alexander Vučić and his comments earlier this week?
Well, if I may, please, Bekim. I think that Serbian revision is...
Just stay close to the mic.
Yes, the Serbian revisionist attitude started with forceful degradation of Kosovo's autonomy in 1989. And that logic is continuing in today.
1989.
1989, yes.
Yes.
And so what Milosevic did in 1989, it was actually a revisionism that was a starting point for dissolution of Yugoslavia, even bloody dissolution of Yugoslavia. And this has been done by Milosevic. The very same logic is the same in Belgrade today, and we shall not forget that Vučić, few years ago in 2018, he was praising Milosevic as a great leader. And we shall not forget that Milosevic was the one who was in charge for Serbia's violation of international law and basic human rights throughout all 90s of the last century. And when we come right now to International Court of Justice, it was Serbia that has asked this question. And Serbia right now doesn't want to recognize the advisory opinion that it has asked for. But we shall not forget another element, that prior to independence of Kosovo, Serbia did everything what it was at its power to oppose and to undermine United Nations mission in Kosovo. And after the declaration of independence of Kosovo and recognition of Kosovo by more than 100 states, Serbia right now tries to go back in history and somehow to claim and to ask, how to say, a kind of shelter in the resolution 1244 of United Nations Security Council, which according to the International Court of Justice was not violated by the Declaration of Independence. And this is the hypocrisy of Serbian policy. Serbia has not cured itself from its regional post-imperialistic, if I may name it in this way, complex from the past. Why Serbia is revisionist power? Because it is not able to accept relations in equal footing with its neighbors of former Yugoslavia. This is not only the case of Kosovo, it is the case of Montenegro, it is the case of Bosnia and Herzegovina, it tried a lot with Croatia, and obviously in Macedonia. So this is my answer about it.
Thank you. Well, very clear and lots of implications and things we could discuss from that, including the open Balkan of if a country, the country with the largest economy cannot accept proper relations on an equal footing with its neighbors, particularly Kosovo, Montenegro, Bosnia-Herzegovina, then what about an economic platform that increases its relative economic advantage? But let me keep it to the topic, and I'm actually going to turn now really to the crux, the crux of the whole issue here, which you've put it out, Putin's revisionism, this blatant hypocrisy, trying to have it both ways here, making this fatuous case and comparison, and at the same time even refusing to recognize Kosovo and stating, oh, they will never recognize Kosovo. So we've addressed that. You've addressed the revisionism of Serbia under Alexander Vučić. And now we come to the crux, because we come to, not from your fine paper, Luli, to the report that you and I and other colleagues wrote here at SICE and published by Wilson Center, SICE and Wilson Center in January, From Crisis to Convergence, a strategy to tackle instability in the Balkans at its source. And the source we identified is not really the Serbian position, it's the enabler of the Serbian position, because Serbia can have a position it wants. Some countries can have outrageous positions, but its ability to frustrate Kosovo's international standing and its ability to continue to destabilize the region under Alexander Vučić is because not of Serbia's inherent power. It's relatively stronger. It's a relatively bigger country than its neighbors, with a bigger economy than its neighbors, but it doesn't have this power except insofar as 5 EU countries, and 4 of which are members of NATO, give Serbia this power. So, and we explained that in the paper, that the Serbian position is not really problematic, is if only 4 of them, the ones who are in NATO, would themselves recognize or even move forward towards recognition, because then Serbia's position, essentially its leverage over Kosovo would diminish or be gone altogether, and it simply wouldn't be a problem. And in the end, there would be a dignified